So there are two kinds of people who need labor law assistance now. One is companies which are in India but growing very fast through investment. So these are often technology driven companies. But even if there's a non-technology driven company which gets that venture capital investment and is scaling up, it is going to be interested in labor law compliance. Why? Because a lot of money, whether Indian or foreign, nowadays investors will insist that there is all legal compliance in India. And in case there is any violation, then they put a personal indemnity on the founders, meaning the founder has to personally indemnify them. The other problem is that where there is an imprisonment, if the founder is a director and he gets imprisoned, there is no way to indemnify an investor against that, right? So, and that will be a big risk, because if your director or your promoter is in jail, he's not going to be able to fully run the affairs of the company. So business is going to suffer. So these people are the ones who need you to help them in with labor laws. Now, what are the kinds of assistance you will need? So this is one leg. One second, I'll go back to what kinds of people need help with labor laws. One is these companies which are scaling up rapidly. Another set of companies can be Indian subsidiaries of foreign companies, which may start out as smaller enterprises, but then organically grow in India. Okay. So Amazon sets up shop in India, Uber sets up shop in India. Now they will start having to deal with labor laws the moment their team or fleet expands. Now, Uber, for example, Uber has a lot of work around labor laws for their in-house teams. And because a lot of lawyers do not have a grounding in labor laws, or in their in-house, when they are appointed as in-house counsels, they tend to struggle because they need to rely a lot on HR managers, or even HR managers. Most of the times when we teach labor laws to HR managers, we realize that they have been doing something, they've been following certain practices for, let's say, making an adjustment for PF or payment of gratuity as has been instructed to them by someone else, okay, which is either inherited down or which is what the consultant, who's the outsourced consultant, is advising. That's how companies are dealing with labor laws. Okay, now this is where exactly there's an opportunity, because there's a transparency. The government is going for a transparency drive. There is risk against litigation that can arise from employees. There can be inspections. All of this can happen. Now there is an opportunity that labor law actually becomes not just a question of having somebody who's a wheeler dealer or a fixer as your consultant, but systematically complying from beforehand. Okay. Now, what does that mean? What kind of opportunity arises there? If people want to comply with it beforehand, firstly, which side are you on? Now, you may not exactly be engaged by an employee, because most employees will be acting through trade unions. When it comes to actions from trade unions, they usually have a union representative who will represent himself, who will represent the employee at they will have a union representative or a consultant to such a union who will represent at any proceedings before a labor court. Financial amounts involved from the employee side to pay may not be very high. They'll be high if there is a highly paid executive who's been dismissed. Okay. But the company always wants to defend itself. Because see, if the company is defending a 1 lakh claim, that claim is not just worth 1 lakh to the company. It may be worth 10 lakhs, because there will be 10 other people situated in a similar position who will file against the company. If on the other hand, you are defending a claim for an employee, let's say for a company or an employee. Now, imagine there's a CEO who's fired by the board, who doesn't have majority, and the investor board fires the CEO. Okay. And he was getting a package of 1 crore a year. Okay. And the severance package that was listed in his contract says he should be paid at least 1.5 crores. Now, that's when he's going to, and the company doesn't pay it, but the board fires them. Now, that's when you will want to defend an individual employee, saying that this is the money duly owed to him. And now this is going to have a very heavy economic relevance. He's going to be willing to pay. If you're helping somebody recover 1.5 crores, he's going to be paying you some money for it, right? A good money. So that is when acting on the employee side matters. When the person is usually a high net worth individual, a rich person, right? A corporate, a white collar employee in an executive level position, that kind of situation is there. For the company side, but when you're an in-house counsel, everything matters. You need to know from the ground level work of, somebody's PF was not paid, payment of wages, gratuity, minimum wage, discrimination in payments between male and women employees, or any kind of thing you need to know, because one, it is going to impact your overall policy of the company. then it will impact the payment. One slight error will mean that there can be disparity in payments to hundreds of employees in a large company, and that way the legal risk compounds, right? So that's when your expertise becomes important. Now, usually how this is being dealt with, as I said, the compliance part is dealt with a person outside the company. The HR person liaises with that person. Finance person is responsible. Finance manager or CFO is responsible for making the payments. And then the in-house counsel is looking at the other stuff, which is legal, like contracts and maybe other strategic decisions. But this part goes missed. Now, when you say that people are the most important assets in an organization, then this is the part that becomes important to deal with. Now, what are the parts? So we saw one is the statutory part. Okay, statutory part is regular at an individual level, payment of wages, minimum wages, and you have the labor code, which is trying to unify. There are 4 labor codes which are in the offing. One of them has been notified, but it has been notified as law. It has not been notified to be applicable to different areas of the country. That is still left. So as of now, none of the labor codes are actually enforced at ground level. But so this is the lowest ground level implementation of the law or compliance where you will be involved if you are an in-house counsel. Okay, this is one part of an in-house counsel's work. Now, the next part is that if you have a big company, there can be questions of trade unionism, collective bargaining, industrial disputes, usually in a factory. But a lot of times software related companies, in software companies, employees are now unionizing. Okay, and while it is not always clear whether a person who's doing this is actually a worker similar to a worker in a factory, in Karnataka you will have an example that you do not need to comply with Standing Orders Act if certain conditions are satisfied. So in a state like now, most IT companies have a base in Bangalore. They have either their head office or a branch office. So over there, in order that the industrial laws are not applicable to you, you will first ensure what? You will ensure that you follow that exception in Karnataka, because you don't want to get into that regulatory mess that no, my workers are technical workers, they are doing code and they are not factory related workers, so we don't need standing orders for them. You don't want to get into that mess. Okay. What are standing orders? Standing orders are basically, you can say, pre-approved government regulated employment contracts which are pre-approved by an officer of the government called a certifying officer. Okay, so so that's how this kind of work would arise in a state like Karnataka. Now, if you're working for a large company which has 5 factories in India, 10 offices in different states, then the whole question again becomes that you will again be involved with this work. So what is it you will be? What are the unique laws? One is unique laws which are applicable to collective bargaining related scenarios. One is Trade Unions Act, one Industrial Disputes Act for strikes, retrenchment, all of that. Retrenchment may then, whenever you are firing employees for non-performance, you'll have to take a look at that. If you are in then Standing Orders Act, which means basically that all your employees need to have a standard contract which is pre-certified by the government. So you'll have to draft it carefully so that every ground that you need to deal with is there in that document. Okay. And for those people to whom it does not apply, then there's a regular employment contract. So that becomes your management, CXO level staff, all of them. Okay. And for them, there's another set of employment related work that's there. There could be work around stock option plans because you want to incentivize your managers and key employees. So there could be stock option plans, employment contracts. Then if they leave, then you want to reverse vest the stock options if they do something unfair. So that is a contractual level of work that arises. Then there could be a lot of work around. So the contractual work is then enforcement of a non-compete clause, enforcement of confidentiality, enforcement of non-solicit, okay, assignment of IP. Okay, these are under the employment contracts that is happening, because you'll have a lot of situations in corporate scenarios where an employee goes, steals a client list and starts soliciting them. Okay, now you will need to identify what are courts saying about non-solicit, what are they saying about non-compete, and you'll be surprised that a lot of things that we think generally are true, like non-solicit, maybe like a post-employment non-compete is invalid. That's what people say, right? So people say that post-employment non-competes are invalid, but there have been situations where if an employee who had entered into a contract for, let's say, 3 years, left the company in 9 months for another company which is a competitor offering a higher pay, the court said that this was actually breach of the employment contract and awarded damages to be paid. Did not specifically enforce the contract, but awarded damages to be paid to compensate the company. So now what was the court saying? This was not a post-employment restraint according to the court. It was a duration restraint for the duration of the employment, because it was a longer contract which was breached by leaving the company from before. Okay, so this is an overview of the kind of work that can exist.